Welcome to Litigation and Capital.
Hey everybody, welcome to an all-new episode of Litigation and Capital with Stephen Mirsky, partner at Mirsky Corporate Advisors. I'm your host, Mike Leon. In each episode, we break down high-stakes legal issues affecting companies like yours, those earning $10 to $100 million a year, so you can turn complexity into leverage and protect what you've built. So Stephen, good to see you. I want to ask you first at the top here, let's talk a little bit about, in today's episode, we're going to talk about procedure, how to win with procedure. So why is procedural law often more decisive, than the underlying facts in business litigation? And can you share some examples where the process kind of determined the outcome of a case?
Sure. Thanks, Mike, for having me. Happy to be here. Procedure is extremely important when you're considering how to decide your strategic outcomes in a case. And it depends on what your objectives are and where you're at. If you're a plaintiff, you're going to want to make sure you can move the outcome along as fast as you can. If you're on defense, then, let's kick it out as far as we can. And there's a variety of ways that we can do this. Some considerations are, well, where do we file? Do we file in state court? Do we file in federal court? If in state court, which state? Is there a contractual provision with a forum selection clause? Do you want to try to invalidate the forum selection clause? Is there a choice of law clause? Do we want to try to invalidate the choice of law clause? These are all certain considerations you can bring into play. And so, by focusing on procedure at the outset, we can try to box in the opponent one way or the other to get the outcome we want based on, our disposition in the case.
So, Stephen, speaking of procedure, let's stay on that. In your history of doing this, what are some early procedural mistakes that most often they kind of undermine the company from a litigation position?
One common mistake is waiving personal jurisdiction. A party could try to quash a summons if they can. Oftentimes, it doesn't make sense to quash the summons because you could just file a motion to dismiss or other or demur if it's in California to try to get the action done. But that is a procedural step you could do. Another frequent procedural step I've seen is what's called a snap removal. So you move you're on defense, you move the case from state court to federal court, and there you try to get the case dismissed or compel arbitration because the standards are much higher for compelling arbitration under the Federal Arbitration Act. And so that's a very common tactic I've seen. There's risk in that because if you don't know the citizenship of all the parties, the plaintiff could respond with a motion to remand and put egg in your face.
Stephen, I hear you saying some of these terms. I would love for you to kind of explain some of these terms in these complex business disputes. So let's start with how do you approach jurisdiction, venue, forum selection? Can you kind of explain some of these terminologies and how much, the difference the forum can make to the result?
Sure. So jurisdiction is, which law will apply, right? Very simply. And you have a kind of a fork in the road where we choose state law or federal law, and if we choose state law, which state, right? And so that's issue number one. Venue is where do we file? So if we decide we're going to go in state court, do we file? And let's say we're in California. Do I file in Orange County? Do I file in Sonoma? Do I file in San Francisco? Do I file in San Diego? Right? All of these have different considerations based on the machinery of the court system itself, right? Do I want to drag things out a little bit? Well, I could file it in LA because it's going to take a long time. Do I want to move quickly? I'm going to try to find a smaller court system. Can I file in these certain venues, right? Does the California code, are there facts that align with it that allow me to with the case that allow me to file in these certain jurisdictions? So those are really important, initial considerations. Forum selection clause is a clause that's in a contract that says, if there's any dispute, we're going to file in whatever state or federal court located in county X, right? And there's a very high bar to show that a forum selection clause is presumptively valid. That was issued by the Supreme Court. And so if you want to try to wrestle with a forum selection clause, you have to have a pretty good grounds to do so. And even if you don't have good grounds to do so, if you can make a colorable argument in good faith without violating your ethical duties, if you're on defense, you can just drag the case out longer so the case can be heard. So I think those are some of the technical terms that you wanted to answer.
Yeah, and I want to stay on more of the technical terms inside of your practice as well. So let's talk about motion practice. First, I would love for you to obviously explain that, but how has motion practice been used to control maybe tempo or the outcomes before a trial in your practice?
Motion practice is really important for both offense and defense, no matter which side of the fence you're on. Because it turns from a legal perspective, it's really important because it's asking the court to do something, right? The court is like a computer system. It needs a program to execute. And the motion is the program you're asking the court to execute. From a cost standpoint, it affects tempo, right? It takes me time and it takes opposing counsel time to draft a motion or to oppose a motion. And so, motion practice is a way to increase cost on both parties, hoping to tire somebody out. In addition, you might just need the court to do something because you need to protect your client's rights. So it's not solely just a matter of driving up cost, but it is a factor when you're looking at, the strategic components of litigation. Common motions are, motions to dismiss. So you have very broadly, we have three phases of a court case. We have the pleading phase, we have the discovery phase, and we have the trial phase. Only 2% of cases ever make it to trial, right? That means the battle is won usually within the pleading phase or the discovery phase. And it depends on what the temperament of the parties are, what the case strategy is for your client, and how deep of pockets we got, right? Money is a key consideration here. So that's motion practice generally. And so within the pleading phase, and let's stick to, I guess, California court or federal court. I'll try to do my best to do both. We have certain types of motions we can file. So a pleading is, broadly speaking, a complaint. A complaint is the operative vehicle to say, hey, I have a problem with you. I'm suing you, and here are the reasons why. The complaint sets forth factual allegations to say, you've done this to me. This is why we need money from you, or some other type of relief. Then you have to serve that complaint. And service is either through personal service or by publication or by mailing, and there's a variety of different rules. But you have to serve the complaint. Now, when I receive the complaint and the summons, now I, as defendant, have the ability to respond. If I review your complaint and I see that there is some sort of legal deficiency, whether it is there's no subject matter jurisdiction, whether it is there's no personal jurisdiction, whether I think you're full of crap and I'm going to just move to dismiss your case, I'm going to file a motion. That motion in California state court is called a demur, and in federal court it's called a motion to dismiss. And I'm going to seek to dismiss the complaint. And the court is going to evaluate that and say whether or not a cause of action or the entire case should be dismissed. At which point the process can restart again, depending on a variety of other factors. Mm-hmm. Assuming we make it past that phase, the next phase is to answer the complaint, right? And an answer is a very short statement that, generally denies most of the allegations contained into the complaint and also sets forth affirmative defenses. After that, I can then countersue the other party if I have grounds to believe that, they have also wronged me. Or I could just sit back and play defense. And so I guess other motions that we can bring in this pleading phase are motions to compel arbitration, motions for removal, right? So we talked about snap removal earlier, and that is a motion to take it from state court to federal court. And conversely, in federal court, there's a motion to remand to take it from federal court back to state court. So these are sort of the maneuvering you can do procedurally on the outset of the case.
Can you kind of, and staying on that, can you kind of take us inside how you would advise a company to use some of these procedural tools? I know you gave a little bit of a brief example, but like just take us inside a little bit more how you would have them use these tools to proactively deter litigation or even, get a faster settlement. And then also, what would you recommend for them that they build in before these conflict arises, like some safeguards that they would put into these?
Let me ask you one question. Do you want me to be plaintiff or you want me to be defendant?
I want you to take plaintiff side first and then defendant side.
All right. So on the plaintiff side, I would study our source material. I would look at, is there a breach of contract action? Are we pleading a contract action? Are we pleading a tort action? A tort action is if someone's like done some sort of physical wrong or economic damage to you, something like that arises outside of the contract. I would look at the primary source documents that we have, some witnesses that we have, to figure out where I can shoestring along to anticipate a defense. Let's say that I've got an action that has contract and tort actions, and that there's a contract action that has a choice of law clause or a forum selection clause that I don't like. Well, I'm going to try to set forth causes of action that are real, predictable, based in the law, that will allow me to circumvent the exercise of that provision because we have things that fall outside of the scope of the contract. And then I will look at, based on our data, where have we had success in the venues that we like? Where do we think that this case would most likely prevail at? And then we would file from there. If I'm on defense, it tends to be a little bit easier. It's not always easier, but it tends to be because the burden of proof is on the plaintiff, right? So we can simply just deny. But if we're trying to use procedure, a very common tactic that I've seen, I don't necessarily implement it because there's, in my opinion, ethical considerations, but a very common tactic that I've seen is someone will compel arbitration, meaning that, and then not do anything to maintain the arbitration. So let's spend some time here. When you compel arbitration, you're telling the court, hey, court, there's an arbitration clause in this agreement. We agreed that we would arbitrate, so we need to go to an arbitrator. And at least in California, the court has said that when a motion to compel arbitration is granted, then the court retains what's called vestigial jurisdiction. It doesn't have any jurisdiction in the case anymore to make any decisions whatsoever. And so what I've seen happen is that you have these cases that just kind of languish in limbo, where the motion to compel arbitration has been granted, but the case just sits there because no one's moving anything on the arbitration side. The court has no power to do anything, and the parties are just yelling back and forth at each other. And so that's a tactic that I've seen used commonly, and it can help drive settlement.
Stephen, let's land the plane on this. For an executive that's listening right now, what is the single most important procedural safeguard that they should put in place early right now, according to Stephen Mirsky?
If you're looking at your own MSAs or other service contracts with your clients, make sure you're putting in favorable provisions for you. A lot of in-house attorneys, and I'm speaking as a former in-house attorney, just use templates. They don't really think about litigation because 9 times out of 10, when you're in a medium-sized business, you're going to cut a deal, right? Let's cut a deal. We're never going to go to court. We don't want to do this thing. Well, sometimes you can't cut a deal. So make sure you have an experienced litigator look at your contracts to make sure that you have the safeguards in place to win. and you've laid the groundwork to counter any potential arguments that an opposing counsel might raise to invalidate the leverage you might have.
Stephen, thank you for the time and insights on this. We truly appreciate it.
Thank you. Thanks for having me.
And thank you to everybody out there for listening to another episode of Litigation and Capital. To connect with Stephen or learn more about how Mirsky Corporate Advisors can support your business, do me a favor right now. Visit MirskyCorporateAdvisors.com. If you found this episode helpful, don't forget to subscribe. Leave us a review and comment. Share it with somebody who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.